You good to go?
Uh, I guess this discussion is going to be about the basics to a claim in a Queen's court and the affidavits that go along with it. Um, the information that's required for the actual claim process is determined by everybody's individual provincial or state jurisdiction. It's always done, from what we've been finding, the United States, even the UK, Canada, they're all within the provincial jurisdictions. They're not a federal jurisdiction. The federal jurisdiction is not where we want to be. And we'll get more into that throughout the process. When you actually make an actual claim to the courts, no evidence can actually go in the claim itself. All evidence goes into a motion that gets you a hearing. When you make a claim, there actually is no hearing date when you make the claim. All your court dates are determined through your motions. And motions can also be done by way of affidavit. And that's where the 6.and Chapter 18 affidavit comes into place, because now we can use that affidavit to submit the motion for the proper jurisdiction and for the proper capacity for your claim. Now this is going to take us into actually, I guess we should stop there and ask if anybody actually has any questions about that part of it, like why you can't put evidence and stuff into a claim and that kind of stuff. If we wanted to start with a question, if anybody has any questions on that. Okay, so I take that as nobody has any questions on that. So what is next is that what is actually required in an affidavit or even a motion that you're going to be presenting to the court. A proper motion is supported by an affidavit, and this is where all your actual evidence goes. Because in a claim, you're writing a claim that is a summary of the facts of the situation, and you only want to discuss what the determining factors of law, not what you believe the determining factors to be, but the determining factors for the area of law that you're quoting in your affidavit, which is your motion. So when we look at that, we have to look at the different capacities, because when we're in a courtroom, there's actually three different capacities. You have your defendant and the plaintiff, and you also have a judge. The judge is bound by a different law than the people. And so that means that we have to have the law for each one of those individuals that are taking part in this hearing. So the basics that we look at for what how the courts determine is that there has to be an agreement for there to be a law. So every individual could have a different agreement creating a different law for them where that does not apply to you. So we need to start off with finding certain information for each of the claims or writs that you're trying to get someone else to perform, because you're saying that they basically injured you. So there was a law that states that they had to do it, and a law that states that they had to do it for you, and then there's a law that states that the judge has to do these things, and so on and so forth. So as we can see, there's actually a law and a jurisdiction for each one, and each one could actually be different. Where when we look at between the judge and the plaintiff and the defendant, there's obviously at least two different jurisdictions there, because the judge is operating in a different capacity. He got into an agreement to act on behalf of somebody else and be bound by those laws to do those things and only do those things. So when we look at the different capacities and all the different and how that all correlates together in the courtroom, we have to show certain things. That the law allows you to do that thing, right? So you have to show that in your capacity that there's a law that says that you can do it, right? And then we also have to show that there is a law that gives you the right over that thing, right? So you have that right, but what about that thing? Because duties and capacities are also transferred with things. So that's why in English law, everything is stuck within a jurisdiction, whether it's an immovable item or a movable item in the real jurisdiction or in the personal jurisdiction. So the things will also fall into an area of law for that thing and for who's holding it and in what capacity, right? That very first thing, what law gives you the right to do it in that capacity. And then we have to look for the law that forces the individual to do or grant thing that in question. So, because if there is no law that says that the person has to do it, then you can't force them to do it because they didn't agree to it. So, for every action, you must basically show these three things, but you also need to show it for all the individuals in that hearing, right? So if there's 10 defendants and you're the plaintiff, you got to do that for each one of the defendants, and also for the judge as well, because the judge is also participating in this interaction. So the judge is also bound by laws and everything else, which other people may not. So when we look at it in that form, the judge himself is required to do certain things. So if we look at the two different jurisdictions, corporate judges only deal with corporate fictions. The Queen's judges, or the ones that are acting in that capacity, like in the United States and other jurisdictions, because they're all bound by that. But what's that? Can you? Yeah, but we're not getting any feedback from you. So now that does anybody have any questions about why we have to show what we show for everyone, including yourself? Because it's pretty self-explanatory because I'm pretty sure everybody that's in the group right now understands law and jurisdiction and that kind of stuff, that it's an agreement and how it kind of happens. So, so I guess if you want, we can move into the release. So then we can discuss how to get that